wing extremists. I noticed that, but then on the left, some of your co-plaintiffs, I mean, the lead plaintiff on this is Christopher Hedges, but you've also got down there, for instance, Alexa O'Brien, who on your page says organized the USDayofRage.org. Very similar, it sounds like, to the Day of Resistance that we just saw from some people who might be characterized by the media as being on the right. And it says that the DHS memos sent to law enforcement across the country stated that organizers of the U.S. Day of Rage were likely high-level cyber terrorists. So that's one of the issues about this is to, you know, terrorists can be basically anybody the government labels as a terrorist, right?
Right. That's the problem, and that's really gets to the fundament of why we brought this litigation, is because the government increasingly is characterizing dissenters of any political stripe, be they left, right, or center, as terrorists if they don't like what they're doing. And that is a dangerous development in this country. We're now we're now over 4,100 days of this war. It's the longest war in American history by far. And the government has taken this as an opportunity to completely remake our civil liberties such that they're undermined, to completely create an enormous federal bureaucracy that is supposed to be hunting down terrorists. It's also a boondoggle to private contractors. Everyone, I think, who's listening should read the terrific piece by Dana Priest in the Washington Post in the summer of 2010, which was called Top Secret Government. And in that expose in the Washington Post, they stated in enormous detail about how there are now 1,200 government agencies devoted to this so-called war on terrorism that has no end. There are over 1,900 private contractors devoted to this war on terrorism. There are almost 1 million square feet of office space, larger than the Pentagon by far, devoted to this, to eavesdropping on Americans, spying on Americans, drones, et cetera, et cetera. And it really has totally reshaped our democracy. And this is what this lawsuit about is one component of it. I think this breach of our liberties is every bit as concerning as the drone strikes, because what this law does, that's supported by both parties, is it allows for the first time the military to make decisions about who is detained and who is put in, whose liberty is taken from them within the confines of the United States of America. The only precedent really in American history that goes against that is the Korematsu case, which was during World War II, when the military rounded up Japanese American citizens and put them in internment camps in this country. And that has been uniformly seen as a tragic chapter in American history, and one that defiled all of our liberties. So that's why we're bringing this case. This law, to get to your point about the chronology, this law was signed under dark of night on January 31st, 2011 by President Obama, while the country was celebrating the upcoming New Year. President Obama signed a law that he had promised to veto and that he had campaigned against.
That should raise red flags with everybody right there, right?
That's right. And it was both parties were behind it. And what this law allows the military to do, and if we have a couple minutes, I can go through this, because your listeners, your viewers are not going to believe this. So what the law does is allows the military to detain in a military prison anyone who, quote, substantially supports al-Qaeda, the Taliban, or associated forces, or anyone engaging in hostilities against the United States. Now, those are totally undefined terms. They're not defined in the statute. 25 years of practicing law, I've never seen a statute that has no definitional section. And it says that these people can be detained until, quote, the end of hostilities, which could be forever. So that means no right to trial by jury, no right to counsel. But it gets worse. It gets much worse, because the ability for the military to detain people in our country in a military prison is only one of 4 things that they can do to anyone that they suspect of, quote, substantially supporting terrorism. And by the way, at the trial that we had last year, the government didn't deny that some of our plaintiffs, who are nothing but journalists and activists, could be brought within the ambit of the statute. But the other things that the government could do to people under this law are, number one, they could give them a military trial, which would be before a judge rather than a jury. They could put them before any, quote, appropriate tribunal. And who knows what that means, but it sounds like a kangaroo court. But the worst thing that this law allows to do is it allows the military to extradite anyone. It's not even extradite, to send anyone without any hearings, without any judicial intervention, to pick someone up in the United States of America and send them to any foreign country or any foreign entity.
Right.
So that means
rendition,
yeah,
and they do rendition correct. Because the implied purpose of that is so they can be tortured in another country and not have to worry about violating, quote unquote, U.S. laws.
Right, exactly. They could send them to some of the worst human rights violators on the planet, Syria, North Korea, whomever. They could send them to any foreign country or entity, they could send them to the custody of the equivalent of the Syrian CIA or the Syrian secret police or the North Korean secret police, wherever. They could send them to places in this world that have absolutely no rights.
And actually, we have seen that in some of the news that broke. It was like 50 some odd countries that had been used for rendition, and in that list were countries that we just overthrew, Libya, Egypt, and Syria that we're trying to overthrow. And those were our partners with the CIA torturing people under rendition. Right.
But what this law, the NDAA, does, it makes it even easier. At least in some of these other cases, there's either some type of hearing or review, or they're first taken into a military prison. But the NDAA gives the military the green light to snatch anyone at any time within the United States and send them to these foreign countries or entities. So we think this is an appalling breach of our civil liberties.
Well, you wasted no time in attacking this. You had a lawsuit, about the middle of January after he had signed it on New Year's Eve? Is that correct?
Yes. We first filed in January. Christopher Hedges, who was a Pulitzer Prize-winning war correspondent for the New York Times for 20 years, he stepped up to be the first plaintiff. And then we were joined, and the complaint was amended later in 2011 to include, 2012. Later in 2012 to include Daniel Ellsberg, who is the whistleblower behind the Pentagon Papers, and a group of activists.
And now you won an injunction you got a temporary restraining order in May, and then that judge gave an injunction in September to actually stop the enforcement of this. That's correct?
Yeah, we had a trial in federal district court in New York before Judge Catherine Forrest, who wrote, I thought, an extraordinary 68-page opinion in May, granting a preliminary injunction which stopped this statute cold in its tracks. The judge then decided to hold an additional hearing after the first trial on a permanent injunction to decide whether she would permanently enjoin this. And that injunction was issued on September 12th. So it was really, I thought, a hard-fought victory. Judge Forrest deserves a lot of credit. You can read her opinions on stopndaa.org for your listeners.
Right. It's amazing. It's about a 200-page opinion, and it's really strong. She agreed with you about the specificity issues and the terms that were there, and she says the Constitution requires specificity. Like you said, you've never seen a statute before that had no definition of terms at the bottom. It's pretty amazing. But we're getting close on time, and I want to talk a little bit about this most recent trial that you had. So basically, she put an injunction on, and then a federal court put a stay on her injunction. Is that the correct legal term? So essentially, they kind of stopped what she was trying to stop and let it go. So the government can now essentially enforce this NDAA until the appeal.
Right. Well, yes, they put in a stay pending appeal. This is a little bit technical, but it just meant that there was a stay pending appeal until the Second Circuit Court of Appeals, which also sits in New York and is the highest appellate court before the Supreme Court, until they can rule on the merits of this, the government can continue under this program. Although I would like to think that the government would be very, very hard pressed to pick up people like our plaintiffs and stick it in the eye of the courts while this is going on. But you never know what the government will do. Now, and they've changed. Yeah. So I'm sorry. Go ahead.
Now, to make this clear, your case, you're picking up journalists and activists because there's an issue of who has standing to make a clear case. We can't just pick a random citizen out. But of course, as a journalist, I'm not satisfied to see due process upheld for only journalists, and I'm sure you aren't either. But you've got, you know, we want to see it for all persons. That's what the Constitution addresses, is all persons. It doesn't even narrow it down to citizens, as the Feinstein-Lee Amendment tried to carve out protection for citizens and legal residents, you know, for due process. The Constitution talks about persons. So, I'm sure we want to see that. But now, specifically talking about the journalists, one of the things that I wanted, in the brief amount of time we've got left here, the Justice Department attorney, Robert Loeb, is that how you pronounce his name?
Yes.
Said that no journalists had been detained by the U.S. since September 11th. But then, of course, I think you talked about the case of Sam al-Haji, an Al Jazeera cameraman who was sent to Gitmo.
Yes, that's right, Sami al-Haj. And they actually, the government slandered him at the hearing because they claimed that he had supplied Stinger missiles to al-Qaeda. But if that were the case, they would have charged him. They never charged him. He was released without being charged. So you can't do that.
Right.
And to be clear, even though our plaintiffs are journalists, the Judge Forrest injunction applied to everybody. And she ruled that the statute was unconstitutional, and that means everyone will be protected if we win.
Yes, yes, good. Yeah. Good, excellent. Yeah, it's truly amazing the double talk that we see. You know, Obama saying he's not interested in signing this, but then doing it in the dead of night, saying he's not interested in using it, but then he fights tooth and nail to stop this, to put a stay on the injunction that stops it. So it's very concerning to all of us to see this and to see what is essentially the overturn of centuries of legal protections and due process.
Yeah, it really is an egregious undermining of Americans' liberties. It's what we fought the revolution for. The British were fairly consistent in violating what we call our liberties at the time. They would knock down people's walls and use the military to detain people. And that is why we passed these constitutional protections, particularly the Fourth Amendment and the First Amendment. And that's why we still fight to preserve them. Unfortunately, by and large, the courts have taken a hands-off position with some exceptions. Judge Forrest, I thought, was very courageous, although her opinion is grounded in substantial precedent. So we're going to fight this as long as we can.
It was very impressive. She's a relatively new judge. The brief is amazing in its strength, and it's also amazing she was an Obama appointee. So, you know, three cheers for Judge Forrest. But tell us now where this goes. Is it still going to, and when is there going to be the next hearing? And how far away is it from a Supreme Court decision?
Right. Well, the Second Circuit, a panel of 3 judges, has this under consideration. We had oral arguments about a month ago on February 6th in Manhattan before the 3-judge panel. They will issue their opinion. It could come down any day. At that point, certainly if we win, we will again call on the Obama administration and the Republican Party to end this assault on our liberties. They have not shown any